Members of the jury, in this case, plaintiff claims that at all the times in the complaint mentioned, the defendant was and still is a domestic corporation organized and existing under and by virtue of the laws of the state of New York, that on or about December 21st, 1995, defendant entered into an agreement in writing with the plaintiff whereby the defendant employed plaintiff as a designer of men's clothing for a term of 1 year beginning January 5th, 1996 and ending January 5th, 1997. That in and of itself, the terms of the agreement of the defendant were that he was to pay plaintiff for his services the sum of $185 per week at the end of each successive week during the time of said employment, except during the months of July and August, plaintiff was to receive, and the defendant was to pay the sum of $50 per week. And in addition to that compensation, plaintiff was to receive the sum of 10% of the net profits of the business of defendant for the term of his said contract, after deducting such sum which the plaintiff received as salary, all that is admitted by the defendant. Plaintiff further claims that he duly entered upon the employment and continued therein, and duly performed the conditions of the contract on his part to be performed until on or about May 12th, 1996, when defendant broke said contract on its part, and without any right or cause wrongfully discharged plaintiff from said employment, and refused to permit him to continue therein. That by reason thereof, plaintiff has and will suffer damages, to wit, in the sum of money which would have been paid to him as salary during said period of employment, amounting to $17,937. And then it mentions the 10% share of the profits, which I will omit in view of the fact that the plaintiff does not press that. Gentlemen, as I have charged you heretofore, you, gentlemen, are the sole and exclusive judges of the facts in this case, because in the final analysis, this case turns largely upon the veracity of the witnesses, as you believe them. Now, in order to determine the credibility of witnesses, you may give consideration, gentlemen, to the manner of each witness on the stand, to his method of giving his testimony, to his motives insofar as you can discover them, and especially, gentlemen, to the degree of probability inherent in the statements of the respective witnesses. I charge you, gentlemen, it is your duty to find your verdict upon the evidence and the evidence only. The remarks or arguments of counsel or the observations of the court have no evidentiary value and should not enter into your consideration in the rendition of your verdict. The law says that before a plaintiff may recover a verdict at your hands, he must make out his case substantially as he has alleged it, practically along the lines as drawn in his complaint, to your satisfaction by a fair preponderance of the evidence upon the question which goes to make up the plaintiff's cause of action. The law places upon the plaintiff the burden of proof. If the scales are hanging evenly between the plaintiff and defendant, then your verdict will be for the defendant. If, however, the balance tips towards the side of the plaintiff, then your verdict will be for the plaintiff. By a preponderance of evidence is not meant that the plaintiff must produce a greater number of witnesses than the defendant produces. It is not a question of the quantity, but of the quality of the evidence, and the duty of the plaintiff to produce that preponderance of evidence is satisfied if, on taking into consideration all the facts and circumstances, he has submitted to you credible evidence which bears with you greater conviction of the truth than the evidence presented by the defendant. The plaintiff is an interested witness. The defendant is an interested witness. One who financially is interested in the outcome of the controversy is an interested witness. Now, upon the testimony of such interested witnesses, the law is, I charge you, that such testimony is not to be disbelieved, but that it is to be weighed more carefully and scrutinized more closely than the testimony of disinterested witnesses. I charge you that if you believe any witness has willfully sworn falsely upon any material question of fact, You must disregard the testimony of that witness on that question.